effective and restrictive interpretation. If you see the text of the Vienna Convention, it does not refer to, at least expressly, effective interpretation or restrictive interpretation. That is the first preliminary observation. The second observation at the preliminary level is that these two means and methods of interpretation have been most often referred to and relied on by domestic courts and tribunals. I have especially in mind the experience of the Indian Supreme Court as regards effective and restrictive interpretation. The third preliminary observation is what is essentially effective and restrictive interpretation as understood in academic writings, because Vienna Convention does not expressly refer to, so we have academic writings and other things, chiefly academic writings to rely on. What essentially is the restrictive and effective interpretation has not necessarily been referred to as effective and restrictive interpretation. So in other words, the essence of effective and restrictive interpretation is more important than characterization of effective and restrictive interpretation. I can give a domestic law terminology. The experience of India that I have lately has been that the term effective has been very rarely used. But what is the essence of effective has been referred to as, you see, interpretation without presuming any surplusage. So there is an assumption in the interpretation that the legislature does not waste words. So there is a presumption. There are several presumptions, but there is one which we are referring in the name of effective interpretation. On the international basis, it's not called the presumption, but if you refer to any textbook, certainly which is written in India on interpretation, you will definitely find a chapter on presumptions. One of these is that there is a presumption against surplusage, meaning that the legislature does not waste words. So if the legislature has enacted a provision by using a certain group of words, which in the opinion of the interpreter may also have been expressed, enacted by using a different set of words, this would not allow the interpreter to consider certain words in the enactment as waste. And that is where comes the essence of effective interpretation. In other words, this presumption requires the interpreter, the presumption against a surplusage requires the interpreter to give effect to each and every word of the enactment. So the point I am making is, even if on the domestic plane, the category of effective interpretation has not been found in practice, at least in the expression. The essence of effective interpretation has been found in the name of a presumption against surplusage. That is one terminology. The second terminology clarification is that what we have on the international plane, restrictive interpretation. Again, on the domestic plane, the term which is used is strict interpretation. So what we have restrictive, you have strict interpretation. Strict interpretation means that if there are two interpretations of a particular provision, the court must give effect to that interpretation which is within the literal terms of the enactment. So, strict interpretation is also understood by its antonym, that is called liberal interpretation. In other words, strict and liberal, these interpretations are also being employed by domestic courts with reference to the nature of the enactment. Please note the word nature. For instance, if the nature of the enactment is penal or penal considered, penal of course, any Indian penal code, penal considered a tax statute is considered as penal. So in other words, I repeat, it is also on the basis of the nature of the enactment. So if a court is confronted with the interpretation of a penal enactment, penal provision, then the court is going to give strict interpretation, which means that unless the accused, unless the subject may be charged or convicted within the letter of the law, the accused or the subject will be allowed to go or will be acquitted. For instance, if the tax may not be levied within the letter of the law, then the person who is charged must be allowed to go without tax. Because the presumption again is, the argument again is that the liability must be clearly expressed by the legislature. It may not be added by interpretation. Even if there is a plausible interpretation on the basis of which a liability may be imposed, but the courts would decline to give such an interpretation if only the nature of the legislation is either penal or considered penal. That is what is the case. So let us, test these. Yes, please.
Is it either penal or considered?
Both.
What is the difference?
The difference is, for instance, penal is, let us say, Bangladesh Penal Code, for instance, or any provision, by which penalty may be imposed, imprisonment, offences, penal statute. But penal or considered statute are tax statute. So that certainly, if not the whole tax statute, but certainly the charging section will surely be considered as penal. The reason is, if you do not pay tax in accordance with that charging section, definitely in the statute there must be penal consequences. The charging section is certainly considered as. So in other words, if an enactment is only penal, for instance, penal code, name itself, there is no doubt about it. It's a penal statute. But even if it doesn't say that it is penal statute, the essence of a particular provision may also be penal. So it will be interpreted strictly. Example, for instance, Food and Adulteration Act. This is a very significant, penal statute in the sense that the requirement of mens rea has been dispensed with. We often say a crime requires also the existence of mens rea. But here is an exception. The reason is legislature did not require it. On the interpretation of it, read a case called M.V. Joshi. I do not remember the name of the respondent, M.V. Joshi and M.U. Shivdi. M.V. Joshi, I am 100% sure. This is a case where you see, the question was the manufacture of butter, whether you see from milk or from curd. So the point was that the legislature had included only one method of manufacturing, either of butter or of milk. The question was that respondents argued that this is butter, so what is the problem? So the court said no. If it is, you see, we have to be very careful because it is a penal. So that is what we see. So you can see further operation of this. Let us test these effective and restrictive interpretation on the international plane as interpreted as used by international courts and tribunals. We start with effective interpretation, and we start again with a case that you had already read in the different context, the East Indies case. That was decided by the International Court of Justice. We will see the extent of importance attached by the International Court as to a maxim which is known as a maxim on effective interpretation. Very briefly, you are aware of the facts of this case, but please just recall the facts of this case. Remember, it is this case where a tribunal had to be constituted for the purposes of, you see, dispute settlement between these countries, Hungary, Romania, and on the other hand, the other allied powers. The treaty provided that the tribunal shall be of 3 members. Each party will appoint 1 member to the tribunal, and after the appointment of 2 members, the 3rd member will be appointed by both the members on the basis of agreement. If no agreement should be reached between the members, then the 3rd member shall be appointed by the Secretary General of the United Nations. Now, the 2nd member of the tribunal could not be appointed because these countries simply refused to appoint their member. The question arose whether the 3rd member could be appointed, whether the Secretary General could also appoint a member. So it was in this context that this case was referred to the International Court of Justice, and it was in this context that the issue of effective interpretation also came up before the International Court. I recall the clause clearly provided for the appointment of a 3rd member. The text of the clause clearly provided for the appointment of the 3rd member. Now, on this ground, International Court was requested that effective interpretation is to be given to the treaty and a 3rd member should be appointed. Secretary General should not be deprived of merely on the basis of a default, rather a persistent refusal to appoint a 3rd member. This is basically the issue before the court. Now, court made 2 very significant observations in response to the reliance on the effective interpretation for the purposes of appointment of the 3rd member to the arbitral tribunal. The first observation was that it was possible that on the basis of the literal meaning of the text, the 3rd member could be appointed. Then the court makes second observation. The word literal you may quote because it has been used by the court. The grammatical part, please don't quote because I am not reading the text. But the word literal, on the literal meaning, literal word you can put in inverted comma that has been used by the court. On the literal meaning, the third member could have been appointed. It was possible to appoint. The court agreed that if we should give literal meaning, then we could allow for appointment of the third member by the Secretary General, even if the second member has not been appointed. Then the court makes another observation, and then we will analyze. But if we should give ordinary and natural meaning, ordinary and natural you can quote. If we should give ordinary and natural meaning, then third member could not be appointed. Immediately what you can make out is whether or not there is always a discernible difference in semantics between the literal, ordinary and natural meanings. But the court has made a distinction because the court has drawn a very significant inference. Because on the basis of the one meaning, the court is reaching one conclusion. And on the basis of two other meanings, the court is reaching another conclusion. That is one. Then the court clarifies. The court says the principle of effectiveness in interpretation cannot override the clear text of the convention. So in other words, the clear text of the convention to the court meant ordinary and natural meaning to be given to the text. Now here, please be little careful in understanding. Now if ordinary and natural meaning is what the clarity of the text is about, then ordinary and natural meaning is what Vienna Convention also requires any tribunal, any international tribunal to give meaning to the text. Ordinary and natural meaning is referred to in the Vienna Convention. Can we say then the Vienna Convention talks about giving effective interpretation? Or Vienna Convention, let us put it negatively, then Vienna Convention is not without at least implicitly reference to effective interpretation. Isn't it a presumption in the Vienna Convention that the interpreter whose duty it is to interpret the text in good faith is required necessarily to give effect to each and every word? There is a difference. Whether you consider a word as a surplusage, as a surplus, or whether you give a meaning to a term which is controversial, or whether you give a meaning which some consider to be literal, others would consider to be ordinary and natural. There is a difference. Giving a particular meaning, giving a meaning is one thing, and not giving a meaning at all is another. So insofar as giving a meaning is concerned, certainly it is very difficult for an interpreter to survive the test of good faith in interpretation if the interpreter ignores an expression in the treaty. For instance, in the computer classification case, that is also a very good reference on the point of good faith. Although the category of good faith, the test of good faith is not necessarily or always determined on the basis of whether the interpreter has ignored a particular term or not. The category is much wider and there can be many more manifestations of the absence of good faith than merely by ignoring an express term of a treaty. Nevertheless, but computer classification case is a good reference of good faith. Now, here in this case, what the court is saying, that if the text is clear, then principle of effectiveness has no meaning. Then the court makes a very important, one of the, I think this case, that for that pronouncement this case is best known for, that it is the duty of the court to interpret the law, the treaty, rather than to revise them. This is the most profound statement you see made by the International Court. So this is, it comes like this. It came in this sequence. So the point is this. In other words, the principle of effectiveness does not mean, as far as this case is concerned, that the court should ignore the clear text of the convention. Clear text of the convention is what is clear by meaning ordinary and natural. A clarity which requires sacrifice of ordinary and natural meaning is at no clarity as far as judicial interpretation is concerned. So this is very important, and here you find a contrast between the practice of domestic courts and international. Because in the practice of domestic tribunals, even if the text is very clear, but if the statute is penal and there are two possible interpretations, clear enough, both are equally clear, the courts will prefer that interpretation which goes in favor of the accused, in favor of the taxed subject. In this case, the difference is, whereas the category of effective, or for that matter restrictive, on the domestic plane is necessarily premised on the nature of the legislation. In this case, the nature of the legislation has not been reflected upon by the court. Court is not making any reference whether this is this kind of human rights, let us say, type of environmental treaties, human rights treaties, trade treaties, space treaties. So these are different treaties. The court is not making. Obviously, one can say that only one treaty was before the court. But certainly, at least once we have seen these cases, then if time allows me, then I will discuss other cases where effective interpretation was used, and let us also see it, we compare it further with other treaties. So this is what, the two things are very clear. One is this: if the text is clear, then effective interpretation has no meaning. Effective interpretation, you see, assumptively comes in only when there is some ambiguity, vagueness, or you see, other than literal, other than ordinary and natural meaning is what is to be given to the text. Only then the question of effectiveness would arise. Court is saying that, well, this is not the ordinary and natural meaning. That we allow Secretary General to appoint the third arbitrator, where one party has persistently refused to appoint the second arbitrator. The appointment of third arbitrator does not arise in the absence of the appointment of the second arbitrator. So there is no question of, we cannot give effect to this provision which allows for the appointment of third, because it is to be given in the absence of the appointment of the second. So we cannot give effect to the power of the Secretary General to appoint the third, because the same text also says the second is to be appointed. So we cannot, the court is saying our duty is to interpret, our duty is not to revise things. So in the name of effectiveness, we cannot revise things. Well, this was in this case. But let us see the other case, and that is related to a subject that you are currently studying, intellectual property rights. And the case is India Patents case. In order, you see, the way we are going to discuss these four cases, I gave certain amount of thought, you see, to structure in this manner so that you can immediately relate it. Let us see India Patents case, again on effective interpretation. Could you please briefly recall the facts of this case for the purposes of interpretation? You are studying, I think this is second year students, first year, you are studying intellectual property rights. Somebody told me you are second year students, so you must be aware of this. Please tell us about it.
year you are studying?
You are studying.
You are studying or you studying?
You are studying it. This semester we are.
Okay, so you are studying it, you have not studied it as yet. It's a process, that is one. Okay. Are you aware of this case? Please tell us about it. India patents case. This was the first case when going to WTO. You see, in this case, the point, there were certain relevant facts. The first relevant fact was,
Why did you study this semester, this IPR? Did you study this case? Did you study IPR or not? Did you study this case?
Mike.
Mic is there.
Why don't you use mic, please?
Was
Yes, Gustav.
Was it taught in the class or not? Was this case taught in the class or not?
Stop, sir.
Okay. You see, here was the case concerning patent protection in the area of pharmaceutical. Patent protection, one IPR, area of pharmaceutical, country developing, that is India, complaint by a country developed. One set of facts. Then, India being a developing country was benefiting from a so-called transitional provisions within the meaning of the TRIPS agreement, IPR agreement under the WTO, under Article 65 and onwards. Now, one of these transitional arrangements was that a country, I am quoting paragraph Article 70, paragraph 8, a country which has not given patent protection by way of a product in the area of pharmaceuticals as on the date of entry into force of the WTO agreement shall establish a means by which patents application for the grant of product patents in the area of pharmaceuticals shall be filed, and novelty and priority of application shall be preserved until such time as the country brings in a law to give effect to product patents in the area of pharmaceuticals. This is about WTO provision. Then India had a law under section 5 of the then Indian Patents Act which excluded product patents in the area of pharmacy. In other words, it only allowed patent protection by way of process. And you are aware, you see the difference between process and product and its implications. Now, as soon as this agreement came into force, United States filed a complaint against India saying that India is in violation of this provision. Article 70, paragraph 8. India said we are not in violation of this because our duty is not to grant product patents in 1996 when you were complaining. Our duty is to do it in 2005. India said, well, you don't understand what our complaint is about. We are not saying that you grant product patent today. What we are saying is that you receive patent applications. So India said we are receiving. If your problem is that we receive patents applications in the area of pharmaceuticals to grant product patents after 2005, we are doing it. So what is your problem? United States said our problem is the manner in which you are doing it is illegal. Why? Because you are doing it by administrative instructions issued in violation of a law, that is section 12 of the Indian Patents Act, which required the examiner immediately upon receipt of applications in the area of pharmaceuticals to examine those applications if the applications were to be found against the provisions of 1970 Act, then to reject those applications. Look at a peculiar situation. The peculiar situation was, first, your receiving application was illegal, and even if you did not reject those applications, that rejection was illegal. Both as a matter of not international law, constitutional law of India. WTO did not say that to adopt one way or the other to effectuate your international law obligations, because Article 1 of the TRIPS agreement clearly says that members are free to determine the appropriate ways, means to effectuate their obligations. The question was, both these acts of India were doubtful, were of dubious legality as a matter of domestic law. And then comes the deduction, then comes deductive reasoning. The reasoning was that if you are complying with an international law obligation inconsistently with national law, then you may not be presumed to be complying with international law obligations. In other words, a dubious means of legality as a matter of domestic law of complying WTO obligations may not be deemed to be complying with WTO obligations. Now India said, you see, this is our freedom. You see, we are doing it by administrative instruction. We were asked that, look, India said nobody has challenged this administrative instruction. The United States argued the fact that nobody has challenged does not mean that nobody may challenge. The fact that you have not been caught traveling without ticket doesn't mean that you may not be caught traveling without ticket. Maybe you are good luck. Those two situations are different. You see, this is what was happening. Now it was in these contexts, these set of complex facts and interpretations of domestic law that the case went to the WTO. As far as the interpretation and within interpretation, the word effective interpretation is there. Now let us focus more closely to other provisions of WTO. There is a preamble to the WTO agreement. Appellate body, while ruling against India, employed the means of effective interpretation. One source of which, one branch of which it found written in the preamble to the WTO agreement, to the TRIPS agreement, not WTO agreement, preamble to the TRIPS agreement, which said effective protection of intellectual property rights. So from there, it picked up the word effective and interpreted the word effective as to mean that it was India's obligation to remove legal uncertainty created by administrative instructions in the presence of a mandatory law to receive patents protection in the area of pharmaceuticals. So two faults were found with India's patent regime on the basis of effective interpretation. One leg of effective interpretation was giving meaning to the word effective written in the preamble. The other was solely a creature of interpretation. And that is what is called a sound legal basis within the municipal law of India. that India was required not merely to reach a result of receiving applications, which India was doing, but reach that result by a means which had a sound legal basis. And even if, in other words, both the ends and means must be acceptable to WTO. It was not enough for the WTO to be convinced that we in fact are. There were 1,373 applications received, I am quoting from the reports. 1,373 patents applications were received, including this Novartis case application that we will come later. This was one of those applications. And not a single application was rejected, and in not a single place did anybody go to the court. So what more sound legal basis you require? They said, look, sound legal basis, we tell you what is a sound legal basis. They said, first you introduce a legislation. You in fact promulgated an ordinance. When you saw that ordinance could not, get the assent of parliament in the form of a law, it lapsed. Then you issued administrative instructions. Now from this conduct, WTO inferred that if you had considered administrative instructions sufficient, then why did you bring in legislation? Look at this. I must warn you again, you see the limits of logic, but look at see how criminals and lawyers most often instinctively rely on logic. Look at this logic. If you had brought in administrative instructions or legislation first, which means that you knew that administrative instructions would not do. So you knew that only legislation would do. So you knew it. So your legislation, your ordinance has expired. You have not introduced a law, and therefore what you are doing is without a law, and therefore we do not accept that what you are doing is it complies with your WTO obligations. So this is notwithstanding the fact that not a single application was rejected, notwithstanding another fact that none of the stakeholders went to the court to challenge this legal situation, but India was found to be in violation of its strict obligations. So this was a very interesting case. This is also a case which I do not think to have been very well argued by India. Yes. I don't see, sufficient reliance placed by India on Article 1. Sufficient arguments for the quality of sufficient arguments on the inference drawn by the appellate body on the basis of legislation and administrative instruction. Very simply, there is sometimes you adopt a course of action which is more permanent, but when that course is not possible for you, then you also adopt a temporary measure. The reason is, since you are adopting a temporary measure in the absence of a more durable measure, it only shows that you ought to comply with the obligations, international obligations. Well, we will debate it further beyond the scope of interpretation. But let us see in this case. The appellate body said, effective interpretation, effective protection of intellectual property rights required of India to have brought in place a legislation to receive these applications as from 1st January 1995. Legislation. And you have not done so. You have admitted by your conduct. You have first promulgated an ordinance, and now you are saying that administrative instructions would be sufficient, by your own conduct, they are not sufficient. Another thing that, well, there we can find fault of India. As far as the appellate body report is concerned, it records that India has not submitted the text of the administrative instruction to the government. That certainly made the India stand very dubious. So if you are making an argument, making a factual submission, then you must be able to put forward text. If you say that I went to leave by applying this, you must give that sanction effect. They did not, as the appellate body record, then India has not provided, and it is a paragraph which contains only one sentence. So you can't read it, you see, misread it. One sentence, India has not provided the appellate body the text of the administrative. And at the same time, admitted that yes, it introduced the legislation. And from there on, once it admitted that legislation was introduced, once it was clear that there is a limit to which an ordinance could go, and at the time when the complaint was made, ordinance had expired. With all these set of facts, appellate body found against it. So this is effective interpretation. That even if it was possible for appellate body to have accepted, because let us try and understand. If you analyze these set of facts, one is a question of the end, the other is a question of means. No application was rejected. It was not in dispute. United States did not submit a single instance where an application was rejected. It was not in dispute that it was not India's obligation to do more than what it was already doing, was to receive applications. Therefore, but the appellate body was not convinced. Appellate body was saying, yes, if you are doing it inconsistently with the national law, then we may not presume you to be complying with international. The argument was, if you see, I have not forwarded to you the panel report, but please read the panel report, especially paragraph 7.34 to 7.37 or 9. 2-3 paragraphs you read. You see, the panel report written by a very renowned professor of international trade law, Professor Thomas Fortier. That reasoning was also sustained by the appellate body. You know what was that reasoning? The reasoning was, this is immaterial how many applications have been filed. What is material is how many applications would have been filed had there been a law to receive applications. Look at this subjective reasoning. You are finding a country in temporal terms of an existing obligation by applying a subjuncting argument. I repeat it. It is immaterial that 1,373 applications have been filed. It is immaterial that nobody went to court. But what is material is how many applications would have been filed had there been a law in India to receive applications. You know what they are saying? It is only 1,373 because you have administrative instructions. If you had a law, then it would have been 13,000. This is sort of an argument. And all other reasoning, chilling effects on economic operators. Many of them did not file applications in India because they were not sure the fate of these applications. They were not sure what would happen if these applications would be challenged, and if they were to be challenged, because this contained such a subject matter where novelty, newness is material, all this will be lost in public domain. So this would be a tremendous loss to private operators. So this had created a chilling effect. Chilling effect is the term used by the panel on economic operators. And there is not a single word in the appellate body's report rejecting this scheme. Although it rejected it in some other sense, why you see, because panel also went one step further, but that is not important for us to discuss this. Well, we will introduce two more cases once we have your comments and reactions. It's 4 o'clock, we will break for 5 minutes or so and come back. But very quickly, any comments, any questions on what we have done on effectivity? Because we have two more cases but not on effectivity. Many more cases maybe which we may add by clarifying your thing that you may give, or I have 2-3 minutes to tell you more about it. Do you have any comments, any questions on this? Effective interpretation, we have seen two cases. One is East Indies case, less controversial, but certainly it will be much more familiar and it's one subject which is of more enduring importance, patents case. You see, there was one more case. In fact, there were two more cases. If you want to read, because that is not possible, so many cases you can read. I should like you to read two more cases on effective interpretation. Both these cases are on WTO cases. One is the beef hormones case, WTDS 26 and WTDS 48. One is a complaint by Canada and another is by United States. Identical panel report. You see, and there is another case, WTDS 152. This is a complaint US Trade Act. The report is of 22nd November 1999. This was a complaint by European communities against the United States. Now, in both these cases, the WTO rejected the arguments of effectivity. And further, we will again refer to these cases when we discuss restrictivity. These cases are very important to see how we did it, and we will compare. You see, it's possible because these are comparable situations. 152 is comparable when we see the fact that is a trade tax Super 301 famous case with India patents case. And one important factor was that I remember, you see, when I was a PhD student, that some people, the government of India was considering of bringing in this case against the United States. And we were also consulted, JV was also consulted. Ultimately, India did not bring in this case against the United States. The result was EC brought in a case against the United States. But the point is, in the meanwhile, United States had already brought in a case against India. So the point is, what would have been the fate of US complaints against India if India had brought in a case against the US? Because both had one thing in common: conformity of domestic law with the country's international obligations. The Trade Act and the same body, WTO. This was 99 and this is, we did it. In fact, we had considered it because Super 301 was very famous at that point in time. Well, unless you have questions, I think we should break for 5 minutes.
So what are the limitations of effective interpretation? This limitation ambit, that how far court tribunal can say that yes, we must interpret effectively. And should it concern with the law with only written preamble as mentioned in TRIPS that effective protection is there, or in absence of that?
Yes, the appellate body has used two devices. One is preamble. Whether or not you use it preamble, you see, appellate body picked up the word effective from there, and it is true, it is there.
I am asking in absence of that effective.
In the absence of effective, then appellate body would have relied only on the sound legal basis. There were two tools, there were two ways in which effective interpretation was given effect in this case. One was the preamble and another was the sound based legal basis reasoning. Appellate body, even if effective protection was not there, appellate body was saying the reasoning was if a country adopts some means which is inconsistent with its own law, constitutional law, then WTO will not accept that country to be complying with its international obligations. The WTO found that we have nothing to say that you have received so many applications. But the question is, your administrative instructions are illegal. What? Section 12 of the then 1970 Act. That is the problem. That was the problem. This was the problem which India could not ask. How can you issue administrative instructions against a mandatory provision of the law? And then there is in the WTO reasoning a distinction between, I am sure you are aware of it, the distinction between mandatory and discretionary legislation. I must also say consistently, it was a badly argued case. It could well have been argued the mere existence of a shall does not necessarily and conclusively make a legislation mandatory. Rani Kusum case, Kanchan Devi case, you read the word shall, the court said it is mandatory, not mandatory. Grammar is a good guide to rule, but a bad master to dictate. And the court has always discounted reliance on grammar beyond a point. We all are aware the importance of the auxiliary verb shall. And in grammar we are aware that it is obligatory. But there are number of cases in which the Supreme Court said shall or may, let us say SR Bomai case, 143, opinion of President, of advice sought by President on Ayodhya case. What did the court say? Justice Ahmadi, we are aware of the word shall, but we will not leave. So what do you do? We have not one case. The question is, nobody submitted it before the court. Then fine, we are aware that it says the patent examiner shall reject. Fine. But here is a sovereign country complying with international obligations, issued administrative instructions in good faith, ensured the legal system, administrative system. Nobody is challenged it, no application was questioned, nothing happened. But the question is, anybody would consider only if you argue. If you don't submit argument, the people won't consider it. They merely pointed out it is a shall, it is mandatory. If it is mandatory, then how can you issue the administrative instructions against a mandatory law? And if you have issued it, it is illegal. So even if you are reaching the same result by illegal means, your end will not be considered to be illegal. That is what the reasoning is. If the means are considered by illegal or improper by the WTO, even if you are reaching the same conclusion, will not be considered as acceptable. That was it. So in the absence of preamble, the appellate body would have relied on the sound legal basis reason. Panel also relied on effective word in preamble. Appellate body clearly approved of it. Appellate body said in one of these paragraphs, I don't remember, somewhere 14th to 15th. Panel is clearly correct. Panel here is clearly correct. Both these points have been upheld by the appellate body. The only point which the appellate body did not approve of was the legitimate expectation reasoning to admit in complaints which are non-violation nature, because they are excluded expressly by by Article 64, paragraph B of the TRIPS agreement. That is the only point on which appellate body disagreed. But as far as this part, legal insecurity, sound legal basis, chilling effect, effective interpretation, all that, complete agreement. There is absolutely no note of dissent, no disagreement. Absolutely. Simply giving a stamp on what the panel did. Absolutely nothing. So we will revert back to those two cases when we see the restrictive interpretation. And those two cases are very important in this context. When you see Read India patents, please also see that case, but we will introduce those cases and we hope we will have time to do it. Let us wait for 5 minutes. the court is expressly or impliedly confronted with the situation of two plausible interpretations of the provision, then the interpretation that the court chooses is the one which is restrictive of the meaning which the court considers to be plausible. Let us just, I told you in the beginning that we have also domestic claim, what we call strict interpretation, which is not liberal interpretation. So you can understand it by its negative, what it is, and as well as what it is not. So restrictive interpretation is not liberal interpretation. Restrictive interpretation is for the domestic claim strict interpretation. Let us test it with the help of the Novartis case. I discuss it first because it immediately comes after India patents, so the subject matter remains behind. India patents, you are fresh with what happened in India patents case. The contrast now is, what is the contrast now? The contrast is that the forum has changed. In the first case, the forum was international. In the second case, the forum is national. And in the international case, of course, the treaty was international, the text was international. In this case, the text was national. Nevertheless, there are linkages because the subject matter was patents. That was the crucial link between the two. Let us see, please recall, this is a very famous decision of this year, 1st April 2013, a very long drawn out, very protracted, you see, a legal battle that Novartis had to fight in this country, and not many articles, one almost full issue or half of full issue of BPW and several others, many writings on this one. Briefly, the facts of this case for the purposes of interpretation. First important fact. I'm sure you must be aware of this, because otherwise we will be problems. Please give him mic. Yes.
There was a component called infatinib, which was the main component of the product medicine which the Novartis wanted to patent it up to 2019. And for that, what it did, as there is a general practice by those pharmaceutical companies that they modify something in the original one, and here they claim that they had modified in the physiochemical properties, like it can sustain more temperature and it will not destroy, something like that. And there is a provision in Indian Patent Act under Article 3 which cannot be patented, and under Article 3D says that a known substance cannot be patented, patenting of new form of known substance unless there is a significant enhancement of non-efficacy. So the court went into efficacy, that whether whatever the physical component which you have enhanced in this product, whether that is having any efficacy in curing the disease, whether that has enhanced the capacity of the medicine to cure the disease or not. So this was in the main discussion. And for the point of interpretation, the court went into several Indian judgments, and basically of 1980s judgments of Chinnappa Reddy, where he says that there are two components of interpretation of a text. One is text and another is context. One gives color and another gives texture, something like that. So he wanted to see through the glasses of those who were there to form this legislation in the same context and same text. So I think
Yes, very good. You made a very good reading of this case, no doubt about it. Anybody would like to add anything to it?
Meaning of the word novel is section 3D. That was interesting.
Yes. Yes, absolutely clearly. See, here was a case before the Supreme Court Supreme Court had to interpret the three provisions which you have correctly stated. Section 2J, Section 2JA, and more importantly, Section 3, paragraph B, in the context of a case which was filed before the Supreme Court by way of an SLP, special leave petition, by Novartis and others. And the substance, the salt, the chemical which was before the court and which was the subject matter of a patent by Novartis was the beta crystalline form of a known and already patented substance called imatinib macellate. Here was this issue. Novartis had already patented, marketed by the name Glivec. Glivec, spellings are different, both the spellings were given. There is Glivec. The known substance called imatinib macellate. Now here, imatinib macellate was not the subject matter. Second important thing is that imatinib macellate had already been given exclusive marketing rights because it had applied for using exclusive marketing rights after having granted a patent in the United States in 2001. Because in 2001, India did not have this obligation. India could not have. The patent application was pending here, that same first case applications. And under Article 70, paragraph 9 of the TRIPS agreement, where the patent application is pending, then you get exclusive marketing rights if you have got a patent. So look at from the economic point of view, look at the situation, the important facts of Novartis. A company claiming a patent on another form of a substance on which it had not merely got a patent outside of India, but effectively no worse than a patent in the form of exclusive marketing rights. Please tell me the difference between, effectively, the difference between a patent and exclusive marketing rights, because these are not merely marketing rights, they are called exclusive marketing rights. If you have only exclusive marketing rights in this country and you don't have a patent, you tell me what are you losing? Which customer are you losing by way of marketing it exclusively, which you would have got if you had a patent in this country? So the exclusive marketing right is as good economically as a patent. So effectively, you had the same market share in this country of the same substance which you had got patented elsewhere. Here in this case, why? The reason was, everybody is aware that if you got a patent in 2001, it would expire in 2020. 20 years time it could expire. Now before 2020, you know it that you have to do something. You are in this field, pharmaceutical company, you will do this. Now that is what in this case was the essence, as many people had argued before the Supreme Court. They introduced this beta crystalline form. So the same salt was introduced in a new form. These are the facts. Let us see the law. The law says, Section 3D, as you have correctly mentioned, significantly enhance the efficacy of a known substance. Imatinib macellate was a known substance. As soon as a substance has got patent on it, it is known. Because unless it is known, it can't be patented. It is known. The question was whether it significantly enhanced the efficacy. Now, there was a lot of evidence before it, and we are not qualified in medical science to actually use that language or whatever it, but as far as evidence is concerned, that was there before. He will use the expression used by the court for the purposes of our legal interpretation. So evidence was before the court that overwhelmingly that it did not enhance significantly the known efficacy of imatinib methylate. The court had recorded in its judgment, most probably paragraph 189, that the Novartis had not submitted any evidence showing that it has enhanced significantly the known efficacy of imatinib methylate. This is a clear-cut finding by the court in paragraph 189. And if that was the case, that in the same paragraph the court concluded that beta crystalline form of imatinib methylate does not satisfy the requirement of section 3D. So that was the end of the matter as a matter of fact. But to read this much of this case is to only read it half, if not necessarily also read it incompletely. Because the court goes further. The court says, our finding, and that is, I correctly remember paragraph 191, that is very important, paragraph 2, after 180. The court is saying, because, and I am pointing out, you see in this case, these two paragraphs for two reasons. One is the interpretive approach by citing the judgments given by the Akbar, that an act is best understood when it is interpreted in the light of the reasons for which it was enacted. But these are other things, and I will respond to it later on because there is a lot of discussion into it why. But insofar as the interpretation of section 3D is concerned, that is why we are discussing this case. Because as far as the reasoning is concerned, if you see that reasoning of Chinnappa Reddy and straight away read from there to paragraph 191, there is a clear inconsistency. I tell you why. Because in the reasoning it records that it was enacted to prevent evergreening. In paragraph 191, the court is making a finding as a matter of law that our finding that imatinib beta crystalline form of imatinib methylate does not satisfy the requirement of section 3D. We are not saying that incremental changes are necessarily precluded from patents. So the point is, they are only academic statements as far as they are made. The actual interpretation was done by the court in two ways. One is a matter of fact. And as a matter of fact, the court made a restrictive interpretation. And since it was a domestic tribunal, and I have told you in the beginning, the domestic terminology for restrictive is strict interpretation. The court used this expression. There, you see in paragraph 189, that the known efficacy, enhancement of efficacy, these expressions in section 3D must receive a restrictive interpretation. What does it mean? Since there was no evidence before the court, if there is no evidence before the court by the claimant, the claim of the claimant falls through even otherwise. It is not necessarily on the basis of interpretation. You make a claim before a tribunal, you don't corroborate the claim, your claim falls through. So there is a difference. Finding as a matter of fact and findings as a matter of law. Please distinguish these two findings. On the basis of factual findings, it's true, the court did make a reference that it must receive strict interpretation. But the question is this, the court at the same time records the factual findings that Novartis did not put forward any evidence. nobody to adjudge whether there is any evidence or not. I am sure there must be some evidence. But when the court is there is no evidence, we have to accept it. Any evidence which is not worthy of consideration, useless, whatever. So there was no evidence. But even if that is there, the court saying that it must receive strict interpretation means that if there are, you see, two plausible evidence. One is saying that there is enhancement of efficacy, and another is saying there is no enhancement of efficacy. We must accept no enhancement. But in this case, that was not the case. So the court's finding is basically as a matter of law, even if stated in the light of a specific claim by the appellants. The second point on interpretation that is not related to restrictive or restrictive interpretation. That is basically the general approach to interpreting statute, relying on object and purpose. And there you read paragraph 190. So people who criticize this judgment saying that this judgment is the one which stops all incremental changes. The court is saying, no, we are not saying it, and it uses so many words to save its position, to saying we are clearly not saying it, it would be a gross, you see, misreading of what we are saying. See, what the court is saying is, to put it, listen carefully, simply. The court is simply saying, in this particular case, as a matter of fact, we do not find any evidence that beta crystalline form has enhanced the known efficacy of imatinib acetate. Therefore, your beta crystalline form does not satisfy the requirement of section 3D. That is the end of the matter. It is not interpreting the law outside of the four quarters of the factual situation. In other words, it was applying the law to a given set of facts rather than to make a law for all future factual situations. The law remains as it is. Whatever section 3D is, court's function is that if you set up facts, we will say whether it satisfies, it doesn't satisfy, and the link between a claim and the judgment is the crucial evidence. If there is no evidence, you will not see your claim true. That was this case. But yes, what is important is in this particular case that having, you see, recorded the history of Indian legislation, the economics, it quoted so much of literature, how pharmaceuticals, you see, companies from abroad capturing its market, and how Indian companies took over, the people in India, the economics of people, the social status of people, diseases, all kinds of things. It is only in that light that the Supreme Court said that we have to use this efficacy restrictively. In other words, the court put a very high burden of proof. In this case, it did not arise. The question we can't say because the absence, if there is no evidence before the court, then the court would, would not accept it. Of course, Novartis said that we have evidence, we have put forward, but that is evidence only in laboratory. So laboratory test, the court said these are no evidence for the purposes of determination. If something is, is certainly of higher efficacy in laboratory conditions, that will not be considered to be an enhancement of capacity, efficacy in normal human beings. So you consume a tablet in a normal temperature, normal requirement. After consuming a tablet, you do not go to laboratory. So obviously, this is a normal condition. Under the normal condition, you tell us 5 different human beings recorded who used this salt and this was the effect. This was nothing. All evidence was laboratory evidence. The court did not consider that evidence for the purposes of determination of enhancement of efficacy. This is how the court gave the restrictive evidence. Now you compare both these cases. Effective protection of intellectual property rights. Now think of a situation. This is pure academic. That is what our purpose is to do. Think of a situation if This is international, this had been international forum. Same law, same conditions. But this case clearly clarifies that the court is not saying that evergreening is prevented or incremental changes, and the court did not use that usage, the word was used incremental changes. That no patents may be claimed on incremental changes. This is not said by the court very clearly. So Novartis case is not a general statement of the law of on section 3D. What you can say, and yes, in Novartis case, section 3D was interpreted, and Novartis was found against on the basis of the absence of evidence of enhancement of efficacy. So if Novartis did not present evidence of enhancement of efficacy, Novartis was found against. Yes, as far as interpretation is concerned, the court said we do not consider laboratory and all those evidence which were there as a matter of record, but was not found to be relevant for the purposes of determination of enhancement of efficacy. So in that case, the court gave a strict interpretation to section 3D. Then even if, let us more fine-tune our statement, even if for the sake of the argument, there was some evidence by the claimant of enhancement of efficacy, but that evidence was not found to be sufficient because the court gave it a strict interpretation. The court put, let us put it, a very high burden of proof on the claimant. Or to, let us put it more clearly, section BC, enhancement of efficacy, requires evidence outside of laboratory. Laboratory evidence is no evidence under section 3D to determine enhancement of efficacy. If there is, even if there is some evidence in laboratory, that is not enough. This must be in human terms. You must have conducted human trials and must have recorded evidence, and then we would have allow you to have a patent process. That is one. But at the same time, the court clarified we are not speaking anything on incremental changes. You make incremental changes and you claim patent. Once you come to us, and then you make a claim on the basis of a particular section, and then we will see whether you qualify under that section or not. That is what the court said. And this is this. Any questions on this point? Restrictive interpretation. In the language of domestic law, the court gave a strict interpretation. That is what we said earlier. That is the terminology that the court uses in this case. Then there was a case, a very famous case, SS Wimbledon case. In that case also, the question of restrictive interpretation came in just as question of effective interpretation came in these treaties case. SS Wimbledon, very famous case, you must have read it in the newspapers also in the last 3-4 months, 6 months, in some context. What happened in SS Wimbledon case? What was SS Wimbledon? See, SS Wimbledon was a ship. Carrying cargo, military, through the Kiel Canal. Germany claiming neutrality under Article 380 of the Treaty of Versailles. prevented the access of assets rebuilded through the Kiel Canal on a right presumption, right because it was subsequently proved to be correct, that the cargo was meant to help one of the parties to the Polish-Russian war. So was the argument of Germany that if Germany were to allow for it, Germany would necessarily side with that party of the war to which this cargo was destined for. And hence, this case. So this was the issue. Now, in this case, the argument of restrictive interpretation came in. The question of the interpretation of Article 380 of the Treaty of Warsaw. Now, in this case, the argument was made that this provision must be interpreted restrictively, allowing Germany on this restrictive interpretation to have less incidence on its sovereignty. And interpretation, you see, here was the argument linked with sovereignty as in other cases that I am going to refer to later on. It is basically that argument, which is otherwise known as by an argument by the principle called in dubio mitius. I-N, first word, second word D-U-B-I-O, and third word is M-I-T-I-U-S. This restrictive interpretation argument basically by this new maxim in dubio mitius is later on used by the foremost tribunal and 152 tribunal. But what it meant essentially was that in case of two interpretations, that interpretation is to be given effect to by the court which has less restrictive consequences on the state sovereignty. Now what does it mean? Article 380 should be interpreted in such a manner as to have less restrictive effects on German sovereignty. Now, court in this particular case said, if that is the case, then every international agreement will have some effect, will have some diminution on the state sovereignty. In fact, if I can roughly quote the statement of the court in English, it would go like this. Every international agreement has certain consequences on a state sovereignty because it requires each state to perform its obligations in one way or the other. But the right to enter into international engagement is nothing but an attribute of state sovereignty. The court is saying it is true that after signing an agreement, your sovereignty will be less, will be reduced by the terms of this agreement. But the question is, it was only your sovereignty that entitled you to sign this agreement. So if sovereignty is reduced by your own sovereign act, there is in law no diminution of sovereignty. Let us take the example of the Gulf War and Chandrasekhar government allowing US warplanes to land there in Mumbai or in Delhi airport. Because the consent of government of India was given, there was no derivation from sovereignty. If the same planes were to land without consent of India was given, there is a diminution of sovereignty. Similarly, you have consented to an agreement. The agreement requires performance of certain obligations in some way. Your sovereignty is to that extent borne by the terms of the agreement. Now, in principle, clarifying this position on this argument, then we should interpret it so that it will have less consequences because Germany is a sovereign country and this is what the interpretation should be. The court again, as in the case of peace treaties case, said it. The question of restrictive interpretation would arise only if the text is not clear. That is where please understand the international approach. And even if this is during the time when Vienna Convention was not there, but again the relevance of Vienna Convention is that Vienna Convention is not merely a codification of a law which came into existence only after Vienna Convention, but it is rather a reflective of a customary international law which was in existence even before the conclusion of the Vienna Convention. That if the text of the treaty is clear, there is no question of restrictive or any other indication. In this particular case, International Court of Justice, Permanent Court of International Justice, read the Article 380 and clarified. Then by this article, Germany had undertaken to allow access of all ships during both war and peace. Now once this was the text, how can you read this without the word conjunction and? So, does it matter? Then here was a ship carrying arms, you should not bother about it. Whatever, you have agreed. Now if you want to claim neutrality, you are most welcome to claim neutrality. Your obligations under this Article 380, the court clarified, are not connected with your free choice as a sovereign country to claim neutrality. You declare neutrality, but it is rather the court has used this expression. The German government was duty bound to allow access to the Kiel Canal by the ship SS Wimbledon, notwithstanding the fact that it was carrying cargo contraband, which would certainly help one of the parties to Polish-Russian war. And as a result of which, Germany was found against reparation, all violation of treaty, whatever. The point that emerges is this: text of the treaty must be read. These categories, restrictive or effective interpretation, as far as the approach of international court is concerned, whether by its name international court or the permanent court, in both these illustrations we have seen, the court is saying that if the text is clear, please accept clear means clear to the court, not to the parties. The court is not saying if the text is clear to the parties. If the parties were to decide their obligations, then there is no need of reference to courts. It is to the court. It may be very clear to you. The court says it is not clear to us. You have to accept it. When we say clear means it is court. If the text is clear to the court, then restrictive or effective this has no meaning because we have seen in this case. Germany's case, the court clearly applied Article 380 and also clarified its position of restriction on sovereignty on the ground that sign any agreement. There is a diminution of sovereignty to the extent that your freedom is gone, which is regulated by the convention. But please also remember that it was your sovereignty which had empowered you to sign this agreement. Only states, sovereign states may sign it in international case. So therefore there is no diminution of sovereignty in this case. Unless you have questions, that I will make those reference to those two cases which will go from here, and there you find this slight difference in the terminology and approach by the court, at least by the WTO. Any questions on this? You see, there were two cases that I told you. One was the G. Formost case, and another was the US Trade Act. Now, in both these cases, both had involved WTO text. In one case, you see, you had this precautionary principle, precautionary approach argument, European communities argued precautionary principle. United States said it is not a principle, it is approach. And appellate body saying that whatever it is, we find that we would not go beyond Article 5.2 and 5.7 of SP's TPP agreement. Clarifying, now restrictive, that in case of a doubt as to a country's extent of obligations, that interpretation is to be given effect to, which has less diminutive effects on the country's sovereignty. The principle called in dubio missions. In the second case, 152 case, US Trade Act case, the context was sections 301 to 310. The power of the United States Trade Representative to impose trade sanctions even without the authorization of the WTO as is required by the clear terms of the WTO agreement, that is Article 3.7 of TSU, and completion of the compliance procedure under Article 1.5 of TSU. Now there, again applying the principle of in dubio missions, the appellate body said, if there is again a possibility of giving effect to an interpretation which will have less intrusive effects on state sovereignty, then that interpretation is preferred. So you can see this restrictive interpretation has, at least before the WTO tribunals, found expressions in the principle called in dubio missions, which the appellate body has applied at least 2 times, meaning that if the tribunal is confronted with 2 interpretations, the one which has got less intrusive effects on state sovereignty shall be given effect to. And in one of these, I don't know whether in both, it has always relied on this SS Wimbledon case, where that expression was made, right to enter into international agreement is an end of state sovereignty. Because there is always some restrictions when you sign an agreement, but it is also true the right to sign an agreement is an expression of state sovereignty. So if your sovereignty has been diminuted by your own expression, then there is no diminution as a matter of law. Well, I'll stop here and I leave the floor to you for your comments and questions.
Sir, in the formal case, I think it was 2010 that European Union said that I am ready to pay you the compensation, but I will not allow your informals to enter into our market, because there were many cases of abnormal sexual growth of the teenagers in particularly Italy and other countries. And moreover, more than that, the European Union, I think Agriculture Minister had made a statement that since it is harming the health of our people, so we will not allow. So although there was an institutional conflict also that the European Union Minister has said, so they have to abide by what the European Union Parliament has said. So there was this also. And second one is that although they had given the data that there were many abnormal growth teenagers in their country, but the special trial, it's like that laboratory trial was not means supporting this. Like experts were appointed to find out whether those were really causing the abnormal growth in the children or not. So I think there was genuine here in European Union that it is causing harm to their people. So since we should look into the why the act was brought, and the name of the act is technical barriers to trade. So technical barrier in the name of health issue, health. So I think this interpretation could have been other way also.
Yes. You see, I see only one point there. A country, even after having been found against, refuses to comply. Now, that problem has not been solved by the WTO. And we should not regret, because that is the problem, where the law comes head on against power. See, what do? You apply trade sanctions, and as you said, this is not happening for the first time in deep hormone case. This has happened in much more aggressively in right amendment case. If you pay for violation, you continue to pay and don't amend the law, don't implement the ruling, continue the ban. US EC is doing what US is doing there, EC is doing there. So they are doing the same thing. Both of it is only these two they are involved. There are two inferences. One is the factual and the other is the legal. Factual is only these two countries, and let us argument sake involve two more countries, Canada and Japan. You tell us in history any other country than European communities in the United States did. No other country can afford to do it, and that is right. No other country did it. And the second is, theoretically, there is no way out. Even there in the context of ICJ and in the context of United Nations, if you don't comply with it, the other party will go to ICJ, other party will go to Security Council. And Security Council, you know it, what happens? If it happens to be a permanent member, you know the situation. So if we don't want to comply, we don't want to comply. But it is also true that only these countries can do it. So EC is doing exactly the same what US is doing together. And you know, US is one of the complainants in EC hormone case. You see, US should have no moral argument saying that EC is doing. EC's position is at least morally the position is much better, because the argument is human health. Ultimately, man is the mother of all things, as Greek said. In the case of Bragg Amendment, it is basically private companies. Then what you are not doing is basically not withdrawing, repealing that legislation which allows private companies to be paid back for successful anti-dumping action and subsidies action. Then Bragg Amendment allows for it. See, for moral claim, EC is on a better, footing than in the United States. But as far as the conduct and law is concerned, both are doing the same. They are what is called pari delicto, equally wrongful conduct. Any other comments or questions? Sir, you may have comments. 27. I am going to discuss the other considerations and conclusions. So half of the class will be on some other aspects of interpretation which have not been covered, one or two minor points, and other on half.
I have more relating to that, so I should do the
Last class. Okay. Yes.
About this Indian patent case, must begin with that. When we go to the first review by ordinate body, it is focusing on preamble, provision, effective protection of IPR. My mindset or my arguments is that then I am willing to compliance with all other kind of IPR, and I am not aligned with just one kind of IPR, that is the pharmaceuticals. Then also looking this way that I am willing to do all work in pursuit of the main objective of this trips. We should not look by this way that I am just not compliant with one kind of IPR. At least I am complying with just, I am living one kind of IPR. I am complying with all other IPR. So, and in one of the case, in another case, I have seen that the arguments that opposite party has not filed any case, and in this case it has viewed this opinion that it is not matter how many cases have been filed, but it is matter that how many cases would have been filed if there had been a law. But in the another case, if you give me time, I can cite that case. It is also against USA and probably European Union. This WTO appellate body find that argument legible. So it is not the restraining attitude of the appellate body to look this preamble in this way, that by just limiting or by just not allowing one kind of IPR, I am allowing all kind of IPR, I am compliant with provisions of all IPR. So our attitude or our action should be looked in this way.
Thank you. Yes, we do also believe that the appellate body was not without some latitude to have appreciated India's submissions in a way that you and many others believe. Now, technically speaking, if you give a technical answer to your comments, then technically speaking, the problem is the terms of reference. And lawyers could all agree that reasons apart, a tribunal's jurisdiction is confined to the claims made in the terms of reference. The patent issue was the only claim made in the terms of reference. Then certainly the appellate body would not have gone beyond it. I appreciate your argument because I know why are you saying it. What you are saying is certainly that if India is complying, India was complying in that particular case, even at that point of time, in relation to all other IPRs, so it was not just in one case. And that is what we say, that it had got considerable language. But we also believe that the case was not well argued. You must also agree, you see the report. It could well have, I am not aware, you see, the pleadings are not available. That is another problem. From the website, the pleadings are not available. We can't be 100% sure as to the contents. Of late, the later appellate body reports, the later cases, you get the whole pleadings. Here the advantage is, here you can be 100% sure what was said. Even, you see, the question and answers. Questions asked of the participants and answers given, they are also very clear. But in this particular case, no record except of the panel report and the appellate body report and request for establishment of panel, there is only one case. That is not a thing. So from what we get from the appellate body report, we do not find it to be a very well argued case. But as far as derivation from the sovereignty, difference to a sovereign state certainly could have been given. This is the most important thing was that there was interpretation, there were rulings before the Supreme Court of India. That in certain cases, if the government is confronted, you see, with a situation where it could not practically enact the law, but nevertheless was doing it for the purposes of complying with its obligation. Article 1 also, you see, allowed for it. that you can establish an appropriate needs. There were other provisions also which were problematic in the text. That I did not discuss because they were outside of the scope of our discussion. But let us see, please read Article 65, paragraph 5 of the section. Although it was not expressly referred to, but the very reasoning of the panel and the appellate body was to a certain extent premised on the expression used in this provision, saying that this effectively says that the countries which are benefiting from transitional arrangements such as Article 70, paragraph 8 and 9 shall ensure that their reliance on their benefiting from transitional arrangements shall not result into a lesser degree of a conformity. That is a very important thing. So don't forget that this sound legal basis reasoning has no linkages with the expression lesser degree of conformity. Now, test it. The argument was on facts. 1,373 applications were filed. No applications were rejected either by the examiner. No claim was made to the Supreme Court. These factual situations were found to be insufficient only because there was a lesser degree of conformity. The appellate body is saying, we agree what you are doing is nice. We have no problem. The point is you should do it by legislation. You have not done it. You immediately tried for it and therefore you are in violation. So let us see the text and also. Now technically we must have to side with the appellate body. The only thing that the appellate body could have adjudicated upon or stated. Yes, but it could have appreciated the argument. It had the latitude to do so. It did not. Any further